Okay. Good afternoon, noon, everybody. Good day, everybody. It's 12:30. Welcome to the immigration section update on immigration and the entertainment sector. This is an update. If any of you attended the CLE, I think it was last April, about O visas and P visas in the entertainment sector. This is sort of, we wanted to provide an update with the new administration and COVID restrictions with regard to entertainers coming to the US and to Canada. And our speakers today are going to be Zoe Kevork, Rachel Baskin, and my co-chair, Maggie Stewart. And our moderator today is going to be Catherine Ross. So for our committee, we'll be having a regular committee meeting on the 10th of December. And also your CLE certificates will be sent out, I think, within the day or a couple of hours after this is done. So now I will turn it over to Catherine.
Thanks, Joanne. Welcome. I'm Catherine Ross, and I'm the moderator today. I'm a foreign-trained lawyer and practiced law as a barrister in Sydney, Australia. I then lived in London, UK, where I worked as a property consultant. And now I'm in Beverly Hills. I'm a real estate advisor with Sotheby's International Realty. And I'm delighted today to introduce the panel. Firstly is Zoe Kevork. Zoe is a sole practitioner in Los Angeles, California, where her practice focuses on entertainment-related non-immigrant and immigrant visas, primarily O, P, and EB1. She's admitted to the Law Society of Ontario since 2004 and the State Bar of California since 2007. Zoe also works with small and large-scale productions on their cross-border immigration needs. She's a regular speaker with the Academy of Canadian Cinema and Television and the International Economic Forum of the Americas. And she has been a sponsor of Holly Shorts Film Festival since 2018. Next is Rachel Baskin, a founding member of Livits Ayass Baskin PLLC, based in New York. Her practice focuses on employment-based and family-based immigration cases, as well as naturalization applications. Rachel previously served as the chapter chair for the New York chapter of the American Immigration Lawyers Association. She's currently the co-chair for the New York chapter's Local Uses Liaison Committee and for the National Case Assistance Liaison Committee. Rachel is admitted to practice law in New York and in New Jersey. Maggie Stewart is the principal of Maggie Stewart Mundial Law, headquartered in Los Angeles, California. She's a Canadian lawyer and is certified by the State Bar of California as a foreign legal consultant in laws of Canada. Maggie provides a range of Canadian legal services to people in California and beyond. She specializes in immigration opportunities for artists and other professionals working in the arts, culture, and entertainment who want to make Canada their new home or need to travel to Canada for their work projects. Zoe, if you could start us off, could you take us through an overview of the O visas?
Yeah, so just as a quick caveat to get us started, we're proceeding on the presumption that everyone attending has a basic idea of how the O visa works. So we're not going to go into the minutia of the criteria and all that stuff. There will be some of that minutia in the handouts for anyone who is looking for a more in-depth look at how the O visa is structured. But we're going to keep this pretty brief. And then the other thing is we are focusing on the entertainment industry. So, any discussions on athletes, P1s, P3s, that kind of thing, we're not going to be covering that. So that would be a separate webinar, CLE. So with the O visa, there are 3 subcategories. There's the O1A for science, athletes, business, and a fourth, which I forgot. And then that's it. And then O1B arts and O1B motion picture television. And each has their own standard of proof of requirement, with the lowest being O1B arts, which is a level of distinction. O1B motion picture television is extraordinary achievement. And then the highest would be O1A, expertise, sustained national and international acclaim. So when deciding what O visa is going to work best for your client, obviously also taking into account the standard of proof and what you are able to meet with the evidence that your client has. So 3 big buckets for the O visa. One is obviously the criteria. They do vary a little bit between the 3 subcategories, and then who will be acting as the petitioner, and then the employment contract. So those are the 3 kind of big buckets. With regards to the criteria, like I said, they do differ slightly, but generally there is a lot of overlap. You're looking at items like press, you're looking at items like testimonials, expert letters, ratings, salary, that kind of thing. In terms of the petitioner, O visa can be an employer-sponsored petition, or it can be agency-sponsored. Majority in the entertainment industry are agent-sponsored. The agent petitioner, it's not the traditional agent that we would think of in the entertainment industry. It's somebody who is in the business as it's not somebody who is in the business as an agent for the limited purpose only of filing the petition. So they don't necessarily have to be like the CAAs of the world, right? The deal memos. So with the entertainment industry, one of the issues that comes up a lot is how do you cover 3 years of employment to get a 3-year work visa? Immigration is looking very closely to whether or not the employment is prospective employment. So that's something to really keep in mind. We've had instances where, for example, I work a lot with comics, and comedy clubs are not necessarily hiring comics 3 years down the road. So we have had instances where the fraud unit does call up comedy clubs to confirm that the individual is performing on such date 2 years from now, right? So be very careful with what is provable and what is prospective. It can sometimes be a very fine line. And those are kind of the big ticket items when it comes to the 3 main buckets of the O visa. One thing I would mention is when it comes to extensions as opposed to initial filings for O visas, under the previous administration, they had eliminated the idea of deference to previous approvals. The new administration has reinstated that. So while they're not giving 100% deference to previous approvals, the way the immigration officer must be looking at the previous application and see if there's anything that is materially different in the new petition, to use that as a basis for a different decision, for a denial, for example, right? So there is that level of deference given now to previous approvals, which didn't exist about last time we did this seminar. It didn't exist. So that's something that is new and welcome. So those are the big ticket items there. I think the next topic we're moving on to is maintenance of status.
Thanks, Zoe. Yeah, Rachel, could you take us through a bit about the maintenance of status during COVID?
Sure. If you don't mind, Zoe, and please
Yeah, go ahead.
add on to my maintenance of status bit as well. Just 2 other items to think about when thinking about the O1 category is 1, the unions. Every O1 needs a union or peer group, and every union has very specific requirements to what they want. So know your union and get to know them well. Yeah. Some will answer questions, some will not. And the other bit is in terms of the arts, where the work is going to be performed. I'm sure that Zoe has this a lot as well with clients who are doing what the medium is. Is it going to be on a screen where you have to use the motion picture criteria, or is it going to be someplace where you can only use the arts criteria? And be careful how you're creating that argument so that immigration will, will recognize what your artist is doing.
Yeah, and just as an example of that, for example, we get that a lot with musicians. If they're working in soundtracks, for example, we get a lot of pushback and from immigration saying that that would be an instance of motion picture television, that they fall under the other category and not just general arts. So we do get pushback on those types of instances.
Frequently, the union letter can help with that, right? If you have the union letter sometimes.
Yeah.
Right. So just other things just to be aware of in terms of, when you're starting out with the case. And then you have to make sure that the person is eligible to either file in the first instance, has maintained their status before filing, or the person is eligible to file an extension of their status for the O1. So you have to, so the extension of or maintenance of status is you want to be able to show the immigration service that your client, that the artist has not previously violated the terms of their visa. What we're seeing, I would say most commonly now is proof that they've been continually working in the United States. So with the O1, you have to be able to show the immigration service that you were maintaining status by working pursuant to your prior O1 petition. So what work have you been doing? And it doesn't necessarily mean, I work in theater a lot, so it doesn't mean playbills. It doesn't necessarily mean work product itself. Sometimes it's just a matter of showing what you've been doing and using that evidence for a new petition, and immigration will frequently in the O1 category accept that as proof of maintenance of status to show that the beneficiary has been working in the past. Other times, I think all of us have agreed that we don't typically submit pay stubs in the O1 category because it's not necessarily required where it is in other visa categories. But sometimes immigration does push back, and I learned from preparing the CLE that the form instructions for the I-129 for the petition that you file say that you need to submit only 2 months of pay stubs. So when immigration tells you what they want specifically, if they ask for more than that, it doesn't hurt to throw their own instructions right back at them. So showing that you've been continually working and so showing that your client has been continually working either through pay stubs. We've all discussed that we've used other things that we've used are invoices, contracts, emails, anything to show continuous work in the United States, that there hasn't been a violation. This hasn't come up recently, but I guess, March, April of 2020, it came up with what if someone could accept unemployment. And that we always advised no, except in very, very limited circumstances, because the O1 petition, the purpose is to say, well, we're still, we're here in the US working. So if you're accepting unemployment, you're telling a government agency that you're no longer working, which then raises the issue of, well, how were you maintaining status? So in the instances of, where we found it permissible was if someone was going to leave the US shortly thereafter, then maybe it was okay for them to do it. I think that would be more of an issue, and maybe Zoe, I'm interested to see what you think. I think it would come up at the embassy more so and then at the immigration office. Yeah,
because I was part of that webinar last year, and I don't even think we had a consensus at the end of it between the panelists on what is the best course of action. We all had success in whichever way we approached it, right? So there's no real authority on the matter, and I think it's just best practice within your office at this point. Hopefully there's some resolution and consistency at some point moving forward.
One of the things that helped us is the regulations that allow you to be unemployed for 60 days before resuming employment.
Yeah.
So in some cases that meant we filed a new petition, and within those 60 days, if the beneficiary was on unemployment, it would and make a straight face argument that it was permissible because they were saying they were unemployed and then refiling.
Yeah, and one of the things that we kind of relied on was the definition of event for the purposes of the deal memo, because it is a broad, it is a very broad definition. So it doesn't have to be, 3 years back to back. It does allow for breaks. So we had an instance where a company needed to furlough some of their non-immigrant visa employees for a short period. And when it came time to renew, we made the argument based on the definition of event, and we're successful. So that would be another approach.
And I think that I think that as long as you can make the argument, like if you have the argument before, hopefully the person is unemployed, you're certainly in a better position either to file at the service or when you get to the embassy.
Right.
I'm going to use that as my segue for you for consular processing.
Yay. All right, consular processing, which has been a thorn, let's call it a thorn in our side for the last 2 years. So quick side note, not O visa related, but for the green cards, EB1 Extraordinary Ability green cards, which is what we do mostly on the green card side in our office, they have been paused. I mean, there was the executive order under the previous administration, which basically shelved all employment-based permanent residency applications at consulates. While, that has changed, we're still not seeing any movement. So anyone who is interested in applying for permanent residency and is outside the US on the employment side anyway, we are right now telling them that it's at least about a 2-year wait before you get an interview, because I just don't.
It may be longer than that because embassies are not going to prioritize them right now.
No, and it's not a priority at all, right?
So practice may be to do an O and then do the EB1.
Yeah, so that's basically what we're doing. We have several clients who got stuck because they had we had submitted to the National Visa Center and everything. So we have several that have been stuck and don't want to incur the expenses of the O visa and et cetera, because they've already done the EB1. But that's just something, kind of a side note before we get into the O visa consular processing issues.
Quick question, Zoe.
Yeah.
Have you been advising with the pause on the EB1s for foreign people? Do you tell them to just apply now and just wait the 2 years, or have you been telling them to just wait to apply later?
I mean, some of it depends on their circumstance. Some of them have enough going on in their home country where they can wait it out, right? And are fine to just do the EB1 consular processing and wait for interviews to restart. But the majority have work that they want to start as soon as possible. So we are right now encouraging O visas with an EB1 follow-up. Yeah. So again, going to the previous administration. So not only were they barring the permanent residency employment applications, there was a bar based on, the COVID restrictions, barring any citizen from many countries to enter the US. This included all of Europe, basically India, South Africa, and Brazil, I believe.
And China.
And of course, China. That has been lifted. There is a new executive order based on this new Omicron variant that has affected 8 countries, I believe, in the African continent. And the way the executive order is structured is anyone who has been to those countries for 14 days in the prior 14 days cannot enter the US unless they have something called a national interest exception waiver, which have been fun. And the entertainment industry does fall under the national interest exception as one of the categories that they are accepting. It is a bit hit and miss. So if you are working or have clients in any of those countries, or you had under the previous executive order, I've heard all sorts of stories, large budget pictures that couldn't get a national interest waiver, or for their, one of their lead characters or lead actors, and then other much smaller productions who were able to. So, and every country has their own specific ways of handling the NIE application. So a lot of this is country specific and requires going to that country's consulate website and following those instructions really closely. What we end up doing is before we have somebody going down or needing a consular processing, immediately get on the message boards and consult with all of our colleagues to see what's open and what's being successful. So right now it's still a little bit of trial and error, even though the executive order for Europe has been lifted, we are still seeing significant delays and cancellations, particularly in London. Paris, we've had several, and Rome has been difficult. I don't know if anyone has specific experiences with any other consulates or embassies, but on the European side, those are the three that we've been having significant issues with. And then, it becomes a matter of what third country is an option to consular process your client out of. In the materials, there will be a list, a link to travel restrictions. It includes every single country. And if there is an issue or you think there might be an issue, immediately just check on that link. Like I said, it'll be in the materials. And it is updated. I mean, I checked and it was updated last night. So it's very current information. And then, so backlogs, third countries. The other thing to mention would be the new testing guidelines, which were announced yesterday. Again, all of this stuff is very fluid. So, we're giving you current information. Hopefully it remains current for a long period of time. And this information is usable, but it is very fluid. So the new testing requirements to be able to enter the United States requires a negative COVID test within the last 24 hours, and that's regardless of vaccination status. And Maggie, I think you mentioned that rapid tests are also permitted for the US, which I hadn't heard or I hadn't read.
The US allows for rapid and antigen tests as long as they are third party, and including at home tests, as long as they're third party monitored, like the kind that you take through Zoom on the other side. By contrast, Canada requires PCR testing, which we'll get into in a few minutes, but that's, yeah.
Yeah, it was the at-home test that you had mentioned, which I hadn't seen, or I missed that.
Yeah, it has to be the monitored kind, but an at-home test.
Okay. Those are the main issues on the consular side. Like I said, the big one is the time delays and really planning for that. If, for musicians, for example, I have several musicians who need to be on tour. So we're trying to figure out what the best way is to get them a consular appointment, whether, that might right now be going to Mexico and having their interview as a third country national in a Mexican consulate. It requires significant planning. So it's not a last minute thing that happens. You need several months lead time on consular processing right now.
If your client can stay, encourage them to do
Of
so.
course.
I ruin so many Christmases for my clients, so many of them. I tell them to stay.
Yeah.
Their parents hate me and I apologize, but it's notoriously been bad over the holidays only because the consulates are always closed. This time, obviously more so. And there are still expedite appointments available. I'm sure they are definitely few and far between and really have to meet the expedite criteria. I just wanted to mention that it is, but you only get one shot. So put your best foot forward for an expedite appointment. They
are, in my experience anyway, extremely rare. And then, like you said, if they can stay, encourage them to stay. We do the same thing. And we've ruined Christmas too.
There's 48 continental states that they can visit. That's what I always like to remind them in hopes that maybe it'll make it a little bit better. Yeah. And now parents, family members, at least from visa waiver countries, can come visit here. Right. Last year, nobody could come visit here. So there's that. I think we're going to switch gears kind of a little bit just to discuss some ancillary topics regarding special cases in the O1 category and the artist category. So as Zoe started, there's 3 different categories for the O1: the business, the arts or motion picture. And I think that we've done them in every category, quite frankly. And kind of as I said in the beginning, I would encourage you to think of what your client is doing and how you can fit them, and what's the best category to fit them in. And maybe if they're doing something business related, it doesn't necessarily, because remember, business is the highest standard to prove. Maybe even if it's business related, it doesn't need to be in an O1A category for a business professional. Perhaps you can get that person to qualify in the arts. Certainly you need to have some artistic ability, artistic, awareness to be working in a field. Musician, A&R people, producers are arguably, that's very clearly in the motion picture side, but there's certainly some business, roles related or duties related to that profession. So I would, encourage you in terms of thinking of what the person is doing, how can you be creative in what their role is and what they're doing so that they meet the criteria, right? Lawyer and advocate for your client so that they meet their criteria. Some of them won't. There's very clear cases where definitely there is no artistic anything that you can associate with the executive. I think Zoe, you mentioned a music executive or somebody in the in those types of industries who maybe the O1A is really the best case, and it's straightforward because they meet the criteria, right? There's press about them moving from label to label or from label to promoter or something, that very clearly fits within the O1A, so you don't have to be creative in your arguments. It may be right in front of you that the business O1 is makes sense, whereas in other cases, not so much. Sorry, go ahead.
No, sorry. The case that I was talking about was a director of international sales. So it was for a production house, and we just didn't feel comfortable doing the arts route. Right. And the nice thing about this industry is that we love to put things in the trades. So the minute somebody gets this kind of position, immediately it's a release goes out and it is picked up by most of the trades. So you do get a nice, national, international acclaim press category out of it, typically, and it does help. So we just don't try and finesse the argument, and we just go with the O1A typically.
Right, and typically in those cases they qualify. Sometimes if you have somebody who's maybe a little bit lower on in the company on the maybe you can. It is something where you can finesse it to get it into the O1B. Yeah.
And then the nice thing there also is that, you don't have to just rely on the H1B, heavily regulated timelines that come with the H1B visas. The O1A, even though it's a high standard, there is flexibility to it, which obviously is beneficial for any business.
Right. No, for sure. And then no waiting for a lottery or time frame with which to file, and maybe file or not file. So it definitely does lend itself to flexibility. And there if you meet the criteria, I definitely think it's a great way to go. And the industry is such that there are a bunch of options, but it's figuring out which is the best option for what your client is doing really and what the work is going to be.
Should we move along now to the P visas for touring groups and such?
Sure.
Well, I think actually there was, Zoe was just going to give us a quick note on content creators.
I'll try and be quick.
Yeah.
Even though there's a lot. So we in my office have been handling a lot more content creators, YouTubers, and it's becoming a bigger question. There's a lot of things, uncertainties, I guess. There's no real one way to go about getting a visa for a content creator. And, like Rachel was saying, really be wary of what category they might fall under, right? So motion picture television does also capture web content, web series, stuff like that. So if, what kind of content are they creating would be a big question. And, could they potentially fall under arts as opposed to motion picture television, to be able to take advantage of that lower standard. One other thing to keep in mind is, especially with YouTubers, they think that because they are creating content everywhere, or they can create content everywhere and they're getting paid in their home countries, that they can enter the US to shoot videos, create content, and that would be fine because they're getting paid in their home country. However, that is not the case. You know, once you enter the US and start shooting videos, you are earning an income on that. So that is unauthorized employment. And customs, they are kind of catching on to that. So, you know, we have seen instances of people getting denied entry as tourists, you know, if they've got their gear on them, for example. You know, it's just something to keep in mind, that that would be an unauthorized employment. We have had issues in terms of sourcing evidence for content creators. So with television, you have Nielsen ratings. With motion pictures, you've got box office numbers. With YouTube, you know, we rely a lot on Social Blade, for example. But even those metrics they're not explained very well in layman's terms that are accessible and usable for to send to immigration officers. So, you know, we have had some issues in terms of, you know, providing that analysis. You know, for example, YouTube has 3 awards that they give out, which who knew, but Diamond Award is or Silver Award is 100,000 subscribers and above, and then 1 million, and then 10 million. And we got an RFE saying that, well, you haven't established that this is significant because they won the lowest award, which is 100,000 subscribers. What we ended up doing, what's that?
Like the bronze medal for an Olympian.
Right,
Clearly
exactly. They got a bronze medal. How horrible. Right. But we ended up going back and doing like actual detailed mathematics and saying, even with 100,000 subscribers, they are in the top 1% of all YouTube channels, because if you look at the numbers, right? So we ended up doing, in my world, that's complex mathematics. So in our response to the RFE. So, you know, things that just aren't commonly known, and they're not really easily explainable at this point. The information is not accessible. So expert letters really come in handy there, just as a note, if you're working in that area. And then the other thing is a lot of YouTubers are self-employed. They have their own channels. They've incorporated themselves. And in these instances, we've actually been successful in having them incorporate their production company in the US, and also act as their own petitioner sponsor. So even in instances where they are 100% owners of their entity, of the US company, they have been able to sign as petitioner for themselves. As long as you're able to show that the employment is not prospective and there is actual work going on, we have been successful in that way.
I'm gonna move on to the P's.
All right, I tried to be really quick because I know we
fine.
can move on.
I can do a P visa very fast because it's very similar to an O1. The biggest difference is the P is for only 1 year versus up to 3 years for the O. You can only get a P visa for a maximum of 1 year. It is for the entire group and support staff, but the entire group is coming as, you know, as a group to perform in the US. Think of coming to the US for a tour. They are coming here. Everybody in the group has to have been a member for at least 1 year. There's an exception because it's a law, so there's always exceptions. But most of the members have to be in the group for at least 1 year before coming to the US and performing here. And the standards are very similar to the O1 in terms of what you need to show, but instead of showing the lead singer meets the standard, the bassist, the drummer, etc., it's the entire group as a whole meets the standard. So press about the entire group, recordings from the group, tours for the group, all of that, you know, those types of evidence that you would maybe use for the O1 are going to qualify for the P1. But again, the biggest thing is 1 year versus 3 years, and that the group has to have been together for at least 1 year performing together in order to get the P1. And then there are special Ps for Canadians, which I know nothing about.
We actually didn't do these very often. We started doing them more the last 2-3 years. They're the reciprocal exchange program visas. So for Canadians, it would be the Canadian Federation of Musicians has a relationship with the AFM in the US. It's Actors Equity in the US and Canadian Actors Equity. And then the Alliance of Canadian Cinema, Television and Radio Artists, which is ACTRA, has a relationship with SAG-AFTRA. So it's very limited. Musicians, actors, stage and screen would be the main ones that would qualify. And then also the British Actors Equity, there's a separate one with the UK there. And it is, again, 1 year. But because of the reciprocal relationship, that extraordinary ability standard does not apply. So it's a nice opportunity if you can use it. That's it.
Good.
And Zoe, you actually had a little note about posting about drug use.
Okay, it's a pet peeve. I wanted to include it because it's a pet peeve. So I'm Canadian, Maggie's Canadian. A lot of the clients I work with are Canadian. Marijuana is legal in Canada. It is legal in California, but federally it is not legal. And immigration law follows federal law. So, be very wary of clients posting on social media about any usage because it feels normal to them, and I understand that. But when it comes to a renewal, customs officer and consular processing or consular officer, or comes time for a green card, it is a specific question, and they are increasingly following up and checking social media. I know on like the DS-260 for green cards, they do ask for all your social media handles. So they are looking into these things, and putting it in stories instead of as a post does not change things. Just encourage people not to do it. I have started policing clients' social media. It's not part of my job, but I feel like I need to help them through that. So it's a pet peeve. Be wary of it. It's not legal federally. That's what I have to say on that.
I would also want to add that I've had a client talk himself into being sent back at LAX, back to Israel, because he got defensive about the question. Customs found a grinder, I don't know anything about pot. All I heard was a pot grinder. I don't know anything. But they asked him what it was, and then he started saying, I do this all the time. It's totally fine in Israel. And I was like, I'm not even sure if that's true, but he basically got himself into 7 hours of questioning at LAX and deported right back the next day. So I would advise people to maybe gently ask their clients. I mean, I don't think clients enjoy.
Don't be gentle about it. Be direct. You need to be direct.
But also, they get defensive. So, and it's better to be defensive with us instead of at the airport or port of entry. So, yeah.
I like to remind them that drinking is legal everywhere, but weed is not. If they need to pick their poison before they're going for their interviews, etc.
Unless they're going to Canada, which
or
is
driving.
a way to Maggie.
There you go.
Perhaps that's a good time now for us to speak with Maggie about Canada.
Thank you. Yeah, I'm really excited for this opportunity to reach out and share some updates about what's going on in Canada. Just as a note, if you're joining us, if you go to the chat, there's a Google Drive link that will allow you to access some materials, and some more materials will be circulated around probably after the weekend on the O visas. In there, you'll find there's a form that has, or a handout that has COVID travel restrictions and resources. One is for people coming into the United States, so it has the links for the Department of State and all the vaccine and testing and requirements. As Zoe had said, basically the real update right now is that everyone, regardless of nationality and vaccine status, will be required to do a rapid test or an antigen test or a PCR test, whatever they can access, within 24 hours of their travel date. And that goes into effect on Monday. So if you have clients who are coming in from overseas and they're not aware of this requirement, you should get in touch, especially because they may have thought that they had 72 hours and that has changed. So that's that. That standard doesn't for the United States apply to people who are crossing in by land or water crossing. So it doesn't apply to people coming over the border from Canada or Mexico. Now, for Canada, the requirements are a little bit different and just different enough to be tripping up people, especially people traveling back and forth regularly. So for Canada, everyone traveling into Canada must, by land or air, must show a negative COVID test taken at least 72 hours before their flight departs. And the test must be a PCR test. So in Canada's case, rapid tests and antigen tests are not going to be accepted. Right now, Canada continues to have restrictions on people who are entering as visitors or for non-essential, what they call non-essential purposes, if they are not fully vaccinated. So for a long time, Canada had an absolute restriction on people entering as visitors. Since vaccines became more prevalent over August and September, they opened up the borders again for people entering as visitors, but only if they can show that they are fully vaccinated by a vaccine that is accepted by the Canadian government, which includes Pfizer, Moderna, AstraZeneca, Johnson & Johnson, and then Bharat Biotech, Sinopharm, and Sinovac. So it's a pretty limited number. If you are not vaccinated, you will not be able to enter as a visitor. If you are not vaccinated and you're coming on a study permit, a work permit, or another right of entry like citizenship or permanent residence in Canada, you will be subject to the 14-day quarantine requirement. So being unvaccinated and coming to Canada is going to have some real restrictions. Also, effective November 30th, no one in Canada can travel on domestic flights without being fully vaccinated. So Canadian citizens and residents are not able to fly within Canada on commercial flights without being fully vaccinated now. So that's really important things to know about traveling into Canada. And the restrictions, unlike the United States, apply to people entering by land crossings or by air. So the testing requirement is also for people driving over the border. We also, in that handout, have a link to the government list of all, like the country-specific list worldwide that Rachel mentioned. And that, so if you're traveling beyond Canada and the United States and you want to know about what the entry requirements will be, there's a link for that as well. So we highly recommend that you and your clients, of course, stay on top of this. It's really unfortunate when people get ready to get on a flight or get all the way to the border and don't meet the requirements to get into the country they hope to enter. So in the context of the entertainment sector, how does this play out? Well, for Canada, for most types of live performance, so music, live theater, stand-up comedy, people do not require work permits to enter, and they enter as visitors or temporary residents. And because they're entering as visitors and without work permits, they're then subject to the restriction on visitors must be fully vaccinated. And so where this has been playing out in the Canadian sense is that people are putting together tours to enter music groups with their crew, and somebody is unvaccinated, and what happens? So the discussion is this, is that Canada does recognize some limited medical exemptions for vaccination, but again, if you're entering unvaccinated, regardless of the reason or your status, you will be subject to a 14-day quarantine. So anybody who is working with groups that want to travel up to Canada for theater performances, music performances, other types of live performance where you typically don't require a work permit, where you're entering as a visitor. Again, my advice is to make sure everyone is vaccinated, and if you can arrange for somebody, if somebody has a medical reason that they're unvaccinated, you're going to have to arrange for them to be making a 14-day quarantine. Entertainment related work, that also includes, actually I should say, people who are entering as business visitors. So producers, other executives, people who are traveling to Canada to attend conferences, meetings, film festivals. If you were going to Canada as a business visitor, again, subject to the vaccination requirements for Canada and the testing requirements. On the work permit side, which is typically people working in film and television work going into Canada, there have not been much impact on issuing work permits during COVID. And in fact, a lot of film and television production moved up to Canada during COVID because, at least for a period of time, there was seemed to be an easier time bringing people together and keeping them safe in a bubble at different Canadian locations. Vancouver, Toronto, Alberta, Nova Scotia have all been really busy over the past year. Again, technically, the requirement for vaccination doesn't apply to people who are coming in on a work permit, but you won't be able to fly domestically without vaccination, and you'll be subject to a 14-day quarantine. So technically, if somebody can be issued a work permit, they can come in without the vaccine status, but they will have to be doing quarantine. Similarly, as people may or may not know, if a person is entering Canada on a work permit for at least 6 months, so that may be someone who is a principal in a major motion picture or a limited series that's shooting for an extended period of time in Canada, their spouse and children who are under 22 years old are eligible to come as accompanying dependents. The spouse would be eligible to apply for an open work permit. Children are eligible for study permits. So they can have their family come. And how this is played out nicely for some families is that they'll be both spouses are actors. One spouse has been hired on as a regular on a series being filmed in Toronto. The other spouse would like to be able to audition and pick up some jobs while they're in Toronto for that period of time. So we get them an open work permit, and then they're able to work while they're living in Toronto for 6 or 7 months with their spouse. So that's a great opportunity available. That's not COVID related. It's just, it just is. So if you have clients who are planning to go up to Canada for an extended period of time or worried about what's going to happen with their family, there's definitely some opportunities for their spouse and their younger children to be able to accompany and have a great Canadian experience. Let's see. So the other thing that I wanted to talk about, sort of apart from COVID, is to talk about criminal inadmissibility, because there's been some changes recently, and also just to make sure everybody's up to speed on that. So and there's a detailed handout at the link that we can, if you've got questions on this. Under Canadian immigration law, if a person has been convicted of any act that would be considered a violation of the laws of Canada, which includes the Criminal Code of Canada and the Controlled Drugs and Substances Act, they would be considered criminally inadmissible. Now, in Canada, criminal law is federal, and so it's only if they violated a federal law. It does not include Motor Vehicle Act type violations, so speeding, driving without a license, driving without registration and insurance. Those kinds of convictions wouldn't trigger inadmissibility, but things such as DUIs, including reckless driving, possession of drugs, which includes marijuana over 1 ounce, theft crimes, assault crimes, disturbing the peace. And it really doesn't matter if that crime is considered a felony or a misdemeanor in the United States. Canada doesn't have the same distinction. And so pretty much any kind of criminal conviction will probably trigger inadmissibility. a person is considered inadmissible until they are considered rehabilitated. So for the time that they are inadmissible, in order to go to Canada, they're going to need what's called a temporary resident permit, which allows them to enter for a specified period of time. It can be very narrowly issued. So it's only, you know, if somebody has to go to Canada for a meeting or to play a show, it can be a week, or, you know, based on the evidence and based on the needs, it could be 12 months or more. It really depends on the seriousness of the crime that's been committed, how much time has passed, the purposes of the travel to Canada, the evidence of rehabilitation that's presented. Preferably, the way that we get temporary resident permits for people is to apply in advance. Currently it's an online application with the consulate here in Los Angeles. We can request expedited processing for people who have a commercial purpose. So that's people who are going for something that's work related. It's best if we can show that there's a Canadian benefit to that commercial purpose. So we show, for example, if somebody needs to go play in a band at a concert, it's the lead singer, they're critical to that performance, and the performance has already sold, you know, $50,000 in tickets, then we've got a commercial purpose for the trip. And in those cases, we can get expedited processing as quickly as 48 hours. I hate to rely on that, so I would like to get them in much earlier, but expedited processing is available. Regular processing for a TRP that's being issued for someone to go as a visitor just for a personal trip to Canada can take 4 to 6 months. So if you are planning to go to Canada, if you have a client that's planning to go to Canada, especially if they're planning to go for something that's not going to trigger commercial purpose and expedited processing, they need to start to think about putting together an application well in advance of that. CBSA officers have the authority to issue a TRP at the border, but again, that's a risky scenario. Especially if you're traveling with a group, especially if you're traveling to do something scheduled like play a show. So again, we like to get our hands on criminality issues and admissibility issues as early as possible so that we can get a resolution well in advance of anticipated travel. Let's see. How long does inadmissibility last? So you're inadmissible until you're rehabilitated, and there's deemed rehabilitation, which takes place 10 years after sentencing has been completed. So if somebody is convicted of a DUI and they get 3 years of probation, then the clock starts ticking at the 3-year mark when the probation is over. And 10 years after that, they're deemed rehabilitated and they're no longer inadmissible, which is a very long time. And it really only applies to people who have committed a single crime, and that crime cannot be a crime that triggers what's called serious criminality in Canada, which means that the sentence can be up to 10 years in jail. And so most crimes would not trigger serious criminality, but most people don't want to wait over 10 years to be deemed rehabilitated. So so deemed rehabilitation only applies to one conviction, and it can't be serious criminality. And the other way that you can become rehabilitated is by application. You become eligible to apply for rehabilitation 5 years after your sentencing is finished. So if we go back to the DUI example, you have a DUI, you get 3 years probation, you finish your probation, and then 5 years after that date, you're eligible to apply for rehabilitation. So all the way up from the time that you're convicted to the time that you're eligible to apply for rehabilitation, that's a full 8 years. You are inadmissible, and you have to apply for a temporary resident permit for those 8 years until you're eligible to then apply for rehabilitation, which will be a permanent cure to the inadmissibility. So who needs to apply for rehabilitation? So anybody who has 2 or more convictions has to apply for rehabilitation because they're not eligible to be deemed rehabilitated. If somebody has a DUI that took place after December 2018, they are not going to be eligible to be deemed rehabilitated because in December 2018, Canada increased the punishment for drinking and driving in Canada under the criminal code. and the maximum punishment is now up to 10 years in jail. And because the maximum punishment is up to 10 years in jail in Canada, that's now considered serious criminality. And so anybody who's been convicted anywhere in the world of a DUI after December 2018 is now considered inadmissible to Canada for serious criminality and are not going to be eligible for deemed rehabilitation, even if that's their only conviction. So that's the situation. For a rehabilitation application, we require state and FBI background checks, court files, reference letters. It's a fairly involved application process, which again is why we like to take some time to get them prepared in advance, because not only does the processing take months, possibly, but so does gathering the documents necessary to do it. Two things that I wanted to touch on. I flagged the DUI change. Possession of marijuana. Canada, as Zoe had mentioned, legalized possession of up to 30 grams or 1 ounce of marijuana in October 2018. The effect of that for criminality is that anybody who has a conviction for possession of marijuana up to 30 grams at any time, it could be before 2018, is no longer considered criminally inadmissible for that conviction. The tricky thing is that it's a very small amount of marijuana. Most people have convictions that are for under 2 ounces or over 2 ounces, and without getting the specific weight of the marijuana that was involved, it's sometimes difficult to show that they had 30 grams or less, which is the requirement to take a marijuana conviction out of inadmissibility for Canadian purposes. So even though possession of marijuana is legal in Canada now, and it will help some people with convictions in the United States and elsewhere in the world, it's not a guarantee that your past marijuana conviction will no longer cause you problems in Canada. We have to be really careful. And then the other is about expungements. In California, you can get an expungement under 1203.4 of the Penal Code. And we've had mixed results with applying those expungements in the context of applying for rehabilitations and temporary resident permits. The expungement basically reverses a finding of guilt and dismisses the charges. So at law, there's no longer a conviction, and you would think that the Canadian government would honor that for the purposes of inadmissibility and criminality, but it hasn't been the case necessarily. I've found that where people have a single DUI and it's been expunged, typically that will be honored, but people who have multiple DUIs and multiple expungements, sometimes Canada will make them go through the full rehabilitation application process and the timeline that's required for that. So again, having an expunged conviction may not guarantee entry into Canada. So it's a fairly complex field, and I've kind of raced through it. There's more details in the handouts, and of course, if anybody out there has questions or they have clients that are having issues with admissibility to Canada for past convictions, I'm always available. That's me.
Okay, it looks like we have a question, and I'm not sure who wants to take this. It's thank you for this great webinar. Silly question, but do U.S. citizens or foreign nationals have to follow the same COVID testing requirements and traveling to U.S. territories / Puerto Rico? Does this follow the quote entering U.S. section in the materials upon return, or is that considered domestic travel? Zoe, you want to take a stab at that?
I need to read that again. Hold on. If you want to jump in, Rachel, while I do.
You're muted. Rachel, you're muted.
I'm getting there.
Okay.
Is the question, where are you coming from? I think is what determines that, right?
I
If you're
think-
coming from,
I think the question is about U.S. citizens going to Puerto Rico, like to
But
territories
where am
of
I
Puerto
flying?
Rico.
But right, and foreign nationals as well, right? So if I'm flying from the U.S. to Puerto Rico, I don't believe there's any sort of, there is definitely not any sort of, you must be vaccinated to fly domestically in the U.S.
But the question is, does flying to the Puerto Rico count as domestic? Or
Right.
Yeah.
I think yes, but I don't like to tell clients that. In other contexts, but I don't think it applies. If you're flying from another country to Puerto Rico, then I think that it does. You are required. right? So if I'm flying from France to Puerto Rico, I think my guess would be I'm required to be tested.
And as I understand it, it applies regardless of citizenship status or vaccination status, right? So I think maybe the question might be asking whether, as a US citizen, is it any different, right? But it's really not.
I
So
think it's where you're coming from.
Yeah,
is
exactly
what
right.
determines whether you be admitted to Puerto Rico or a US territory.
Yeah.
But so here's the question though. So if somebody flies from California to Puerto Rico, we're not doing COVID testing to get into Puerto Rico. And if somebody's flying from Puerto Rico back to California, they're not needing COVID testing to re-enter.
No, I mean, there aren't the same kind of domestic rules as there are in Canada.
Yeah, no, absolutely. And it's not considered foreign travel to travel between the continental United States and a US territory. Correct?
Yeah.
It appears to be that is the case.
I mean, I would say always just check the links. The United States travel website especially has very good detailed information and very good FAQs for sorting out exactly those.
I would also consider calling the airlines themselves, because every airline has different policies as well, like slightly different policies. So it wouldn't hurt to also call the airline that you're flying with, just to make sure that you are not just meeting the, general requirements, but if they have anything specific to their airline.
Right. The airlines are ultimately the ones deciding all of this, and they're going to make sure that you have the proper documentation, or they're not going to let you on the plane because they get fined otherwise.
Yeah, and I don't know if it's gotten, if there's been any level of consistency on that, but there wasn't earlier on in COVID, right? So every airline was handling things a little bit differently, which is why I say that.
Yeah,
I think they've streamlined it across everything.
Oh, I doubt it.
One can hope.
Okay, so I think that's all the questions. If anyone else has any questions that they think of afterwards, feel free to email us. You can find me and Maggie's contact information on the BHBA website under the immigration section, and we can forward questions on to Zoe or Rachel if that is the case. And reminder that we will be having our committee meeting on the 10th at 12:30, and you will be getting your certificate by email. I think, I don't know, sometimes I get it right away, sometimes I get it, I don't know, within the day. You'll get it within the day. Don't worry about it. I mean, I'm sure we all have so many. I have like 100 hours now from doing these lunchtime ones. Okay, so if that's it, then thank you to everyone who attended, and thank you to all our wonderful panelists, and that's it. Thank you.
Thank you, everyone.
Yeah. Bye-bye.
Thanks very much, Joanne. Thanks, Rachel and Zoe. Thanks, Catherine, for hosting. It's been great.
Thank you.